Wow, you're looking at real live evidence in this case, in the Anthony Kirkland case. It's a really, really interesting and horrific situation. So I want to talk a little bit more about it because of its bizarre nature, because you don't see cases like this every day. So joining me right now is former federal prosecutor Francey Hakes. Francey, great to have you here on the program.
Thanks, Jesse. Great to be with you.
What do you think about this case? It's different than things we usually see where a man gets a resentencing years later with an entirely different jury.
It is odd, Jesse, and in fact, if the accounts that I've read are true, what the prosecutor said, that if they didn't impose the death penalty, the original jury, on the offender, that he would get 2 freebies, the court objected to that and said it was so prejudicial that he merited a new sentencing hearing. I just didn't think it was particularly prejudicial. He was already in prison doing life without, so his statement was literally true. The court just seemed to be picky here, so it is an odd situation.
So funny you should say that, and I'm happy you said that, because I get different opinions. I have one guest who said, you know what, it does look prejudicial, and then another, as you said, I don't really see it. But you know, that's the debate right there, and it doesn't really matter because he is getting that resentencing right now, and we're watching detail by detail. The jury is listening to every single aspect of it. Now, I will be signing off, but Aaron Keller will be signing on. Stay tuned. We have a lot here.
That was a replay of testimony of Demetrius Elder in Florida in a manslaughter trial. The replay is testimony from a previous Stand Your Ground hearing. And while we were in the middle of listening to that, things broke up, probably for the lunch break, in the Anthony Kirkland sentencing rehearing in Ohio. We're going to bring Francey Hakes into the discussion now. She's with us here on Law and Crime. Francey, in that Stand Your Ground hearing, we heard Demetrius Elder say that he thought the victim had something in his hand. Of course, it turned out to be a cup, but that's why the defense was trying to say that this was a Stand Your Ground or a self-defense case, because in the defendant's mind, he had to defend himself from someone who got out of a car inexplicably at a stop sign. Does it add up?
Well, Aaron, it's interesting. The Florida Stand Your Ground law is different than self-defense. It's not the same thing, although it's in the same line of reasoning. And what it means is the person who has murdered or attacked someone else has to show that they had a reasonable fear of receiving great bodily harm or imminent death when they put that death on the other person or the attack on the other person, or when they use deadly force. But it has to be reasonable, and it has to be stand your ground in your own home or in your vehicle. Now,
yeah, Francey, I understand. We're going to have to take a quick break. We'll get back to that answer in just a couple of minutes. We'll be back with more discussion and testimony here on Law and Crime in just a minute. Live testimony there from the Demetrius Elder case in Florida. This is a manslaughter case where 2 people pulled up at a stop sign, one behind the other. They had been at a party. One got out of the car, and as you heard the defendant there testifying in a replay from a previous hearing, he said the victim was right up on him after having been stopped for about 10 seconds. He said it was in no time. That testimony was from a previous Stand Your Ground hearing. Francey Hakes is a former prosecutor. She's here with us now. Francey, why do you think the prosecution wanted to play this in front of jurors in the actual trial?
Well, Aaron, generally speaking, the government doesn't have the burden if the defense is claiming self-defense. Generally, the government has the burden to prove everything at trial. But if the defense is claiming self-defense, then they have to prove that the self-defense that they're asserting is reasonable. And so I assume that the defendant is going to testify, or someone's going to testify, or at least the government has the right to bring in evidence that the defendant has spoken inconsistently. That is, in his initial statements, he did not make any allegations that he was standing his ground.
Yeah, I mean, it seemed to me that the key part of this is this impeachment that we're listening to, the harsh cross-examination there. They're up in his face basically saying, look, you're changing your story. You know, where did this come from? And we've got objections flying all over the place. It's fast and furious.
It really is. And of course, it's always fascinating when the defendant gets on the witness stand, and he may or may not testify in the trial itself. But it's interesting to hear from him in the hearing. He has a good demeanor. He's relatively calm, but he has to admit, which is why most defendants don't testify, that he has given inconsistent statements. And that's always a bad thing for the defense.
Yeah, well, we're going to keep an eye on this one. It's one of the two big trials we're covering right here on Law and Crime. We're going to take a quick break. We'll be back live with more testimony in the Demetrius Elder case in Florida in a moment. Welcome back, everybody. We are live in the Demetrius Elder manslaughter case in Florida, where testimony is going on right now of the defendant. It's being played back from a previous stand your ground hearing. We are also in the midst of the Anthony Kirkland case in Cincinnati, Ohio. That is a death penalty phase rehearing because the prosecutor made some inappropriate comments during the original trial several years ago. We are going to, I think, bring Francey Hakes back into discussion for a little bit here to try to unravel a little bit of what's going on in Elder. So, Francey, we're hearing this recording being played, and it's kind of interesting because it's a stand your ground case, and correct me if I'm wrong, but generally in stand your ground cases, doesn't the defendant basically have to admit to committing the act? They just have to say, this is the reason why I committed it?
You're exactly right, Aaron. And it's a risk that the defense thinks is worth taking because they believe they will be able to convince the jury that it was effectively self-defense under Florida stand your ground law.
Exactly. I'm trying to figure out exactly what the prosecution was really hoping to get out of this, other than the strong cross-examination that we had there. We're going to go back to that court, though, now live and listen in a little bit more. The defense just started a redirect of the defendant himself. That's live testimony in the Anthony Kirkland case. He is accused of killing and was convicted or admitted to killing 5 people. We're back in court with him because at a previous sentencing hearing, the prosecutor impermissibly and illegally made a few comments that just went too far. We were talking about the appeals court case yesterday. You can certainly go online and read it. We're back rehearing the sentencing phase, the penalty phase of this trial. Will it be life in prison or will it be the death penalty? Francey Hakes, former prosecutor, is still on the line with me. Francey, in the first case, the appeals court dialed this punishment back, dialed the death penalty back because the prosecution went too far, and I just sort of cringed a little bit at hearing the police officer on the stand use the phrase serial killer. And, of course, well, in lay terms, that's exactly what this guy is, but I just searched the Ohio code. I don't see that phrase anywhere in Ohio statutes. Is that an example of something that could be just going a little bit too far?
You know, Aaron, it's such a great point. I cringed, too, when I heard it because that can potentially be inflammatory. You know, the state is always entitled to prove motive. Motive is almost never, or never, as far as I'm aware, an element of murder in any case. But the state is always entitled to prove it. But being a serial killer is not really a motive. I noticed the defendant didn't object, but I would think that the state would be a lot more careful than allowing witnesses to use inflammatory language like serial killer, given the reason they're back before a new jury this time.
Yeah, exactly. I mean, the way to do it is to just get up there and say he admitted to these crimes and he was convicted of these other ones. Those are just the facts. Let the jury draw the conclusion that he's a serial killer. If they want to use that word in deliberations, fine, but why risk the case? We're going to be back with more live testimony in the Anthony Kirkland case from Cincinnati, Ohio, when we return here on the Law and Crime Trial Network. Ladies and gentlemen, this is the best replay of an interrogation audio recording I think I have ever seen. The transcript is clear. We can follow along, and we know a little bit about what's coming up ahead of where they're actually playing it. What a concept. Francey, you're a former prosecutor. This is the way jurors like to see it, and yet I see very few cases where it's this clear cut.
You're so right, Aaron. Some of that may be resources because, of course, it costs something to have it transcribed. And then you almost always have a fight between the state and the defense about what the words actually were and whether the transcript is accurate. But you're right. It makes it so much better.
Yeah, I mean, and here they're going over like the Miranda stuff. They're asking the guy if he's tired, and you know, it doesn't really cut to the core of the issue, but they've got to get that on the record.
You're right, and there is no better evidence for a jury to hear than from the defendant himself, and they're going to hear a lot from what I understand in this case.
Yeah, my understanding is this is approximately a 9-hour recording. That's at least what I've heard. I assume this is the 9-hour one. It might take days to get through, but look, it's detailed. This is a case with heinous accusations. We're going to go back to court, though, and listen to this. Follow along, of course, as we can, thankfully, so we can understand what the defendant says. We are listening to an interrogation of defendant Anthony Kirkland in his own sentencing hearing. The question for jurors, will this be a death penalty decision or will it be life in prison without the chance for parole? That's the question. Francey Hakes is with us here on the Law&Crime Network. She's a former prosecutor. Francey, here's where we are factually right now. Basically, the defendant is telling interrogators he was hanging out in the area where they eventually found one of the victims' bodies. This is Esme Kenny. She bumped into him, and then this attack ensued. And he's basically telling them he had been hanging out in that area leading up to the attack. So from an interrogation standpoint, he's placing himself at the crime scene, and they're slowly narrowing in on more and more critical facts here, correct?
That's exactly right, Aaron. I mean, this is kind of long and boring, but what it is doing is it is establishing his presence at the crime scene. You can hear him, though, try to exculpate himself maybe a little bit by talking about this Pedro fellow, who I don't know whether or not he's a real person, but he's certainly claiming that at some point he's not alone. And it should be interesting to hear whether or not he's about to confess. The police are doing a good job of building a rapport and making this seem like a very non-threatening interview.
Yeah, I agree. So, you know, not only that, but what if at some point in this interrogation the defendant decides he wants to invoke his right to counsel? I think that in many of these interrogations, they develop the rapport and they get the defendant to go so far, and they're slowly moving in, you know, with a tighter and tighter grasp. If he decides suddenly to be quiet, they at least have some information that connects him to the crime scene at a minimum, right?
That's right. And they have a lot of details. Remember, they were asking him about the beer and how many beers and what kind of beer. And that may be because there were beer cans or other similar evidence found at the scene, so that they can then go and corroborate to the jury the statement so that the jury can believe what the defendant is saying.
Yeah, exactly. And so, look, they're building the rapport. They're dialing in with more and more detail. And the defendant just needs to be going along with all this.
He does, and in fact, he seems a little sleepy, if you ask me, Aaron, and not at all troubled by the fact that he's being interviewed about a couple of murders of little girls, 13 and 14-year-old children.
Yeah, it's really an interesting interrogation, to say the least. We will be continuing to listen to it here along with you, Francey. This is a lengthy interrogation, though. As I understand it, this winds up becoming approximately a 9-hour interrogation. I believe this to be the same one that we heard about at the beginning of the case that's going to last that long. So, of course, we're going to continue to monitor it. It's so easy with the transcript up on the scene to pay attention to this one. The audio is clear. We will be back with more live reading of that transcript in just a moment. Welcome back, folks. We continue to listen to testimony in the Anthony Kirkland case. This is a murder resentencing hearing. He was first given the death penalty. Jurors are being asked to consider that again because an appeals court flipped the original decision based on prosecutorial misconduct. Francey Hakes is here with me on the Law&Crime Network. She's a former prosecutor. Francey, a couple of things here. First of all, they're zeroing in on specific pieces of evidence. And second of all, you think that there's another reason why the prosecutor wants to play the entire allegedly 9-hour interrogation here.
I do, Aaron. I think there's two reasons here for what's going on. First, they want to play the entire 9 hours so that the jury can see that the defendant is not some sort of slavering lunatic. The defense is using an insanity defense here. So they're going to try to convince the jury that he cannot basically control his impulses, that he didn't really understand whether it was right or wrong. And even if he did, he couldn't stop himself from killing. Police are well aware, especially in a multiple murder case, that is the most likely defense a defendant is always going to use. So they're asking him all sorts of detailed questions to show that he's a normal, reasoning, thinking person who looks at things like pink radios and can tell you the street he was on.
Yeah, I think that's exactly where they're going with this. I think that's great insight. This is a lengthy thing. We're going to be back to it in just a few minutes here on the Law and Crime Network. True to form, court is wrapping up now at about 1:30 here on the East Coast. Again, this is the Anthony Kirkland sentencing rehearing in Cincinnati, Ohio, being reheard because the Ohio Supreme Court ruled that the prosecutor made some illegal, impermissible comments during the original death penalty sentencing hearing several years ago. Francey Hakes is still on the line with us here at Law and Crime. So, Francey, we've heard a lot of preliminary information that basically puts the defendant in the park, in the area where one of the two victims was basically found dead. Not a lot of really critical stuff related to the crime. It's just he's in the area, he's in the park, he's across the street at the gas station, he's hanging out there, he's spending a lot of time there. This will eventually, I think, get to something a lot more sinister.
I think you're right, Aaron, but this is such classic good police work and good interrogation technique because they are really taking their time and building. They're pinning the defendant. They're first building a rapport with him with their non-threatening questions about what seems to be inconsequential matters but could become consequential based on evidence that they found at the scenes. This is really good interrogative techniques where the police are really building to when they're going to probably ask the tough questions.
Yeah, and of course the benefit is that on the tail end of it, if he does say something about some of these pieces of evidence, he's talking about a watch, and they're asking him, what kind of watch? Digital watch. And then you're talking about some kind of a radio. Well, what kind of radio? It's a pink radio. If they find this stuff, and then it turns into something big or they can test it, it basically adds credibility that the defendant is telling the truth in an interrogation, and they can count on his words.
It does do that, Aaron. And it also fixes the problem that sometimes the state has, which is the defense saying you put words in his mouth or he was just telling you what you want to hear. These are his details. They're not suggesting a pink radio or which street he was on. He's volunteered that information. So it makes the whole interview more credible.
Exactly. We're just hearing that this case is going to go back into session tomorrow at 9:15 in the morning. They wrap up a little bit earlier in the day. Look, and Francey, just to sort of wrap up our discussion here a little bit before we dip into some other topics, I see it in cases where I was a journalist where people said things to me at a crime scene or whatnot, and they didn't mean a lot in the moment, and then years later, that turns into a big piece of it. And it's possible that some of these little details we're hearing in this interrogation could turn into much bigger pieces of the puzzle.
Well, it does. And for example, talking about the beer that he was drinking, maybe they found those beer cans, got his DNA. That might have been a critical piece of evidence in identifying him by tying his DNA to one of the two children that he killed, in this case, the 13 and 14-year-old girls who were victims. So you never know what's important.
And my understanding is that yes, that may be exactly where this thing went. So we're paying attention to this in real time, even though a lot of this evidence has been out there before. But look, that case is going to be back in session tomorrow at 9:15 in the morning. We are going to switch gears a little bit here on the Law and Crime Network because, of course, we're covering two trials. The other is the Demetrius Elder case in Florida. That's a manslaughter case, a stabbing at a stop sign after a victim and a defendant were at a party. Then it turned into possible case of road rage, an altercation at a stop sign on the streets. Is it manslaughter? Is it not? That's the question for jurors. We are waiting for testimony in that case to resume. They're on a break right now. We will be back live in that case as soon as things pick up this afternoon. In the meantime, we're going to get you caught up on some of the top headlines.
Here are today's top crime stories trending on lawandcrime.com and across the country. A handyman in Arizona was arrested after he allegedly shot a homeowner who hired him to fix his air conditioning. 26-year-old Robert Moore of Arrowhead Air reportedly shot and killed 41-year-old Frank Pineda, who hired Moore to fix the air conditioning in his home. Authorities say an altercation ensued, resulting in Moore fatally shooting Pineda. Moore was charged with second-degree murder and is being held at Maricopa County Jail. The FBI has joined the investigation into missing University of Iowa student Molly Tibbetts. The 20-year-old student from Brooklyn, Iowa, went missing a week ago and was last seen going for a jog before her disappearance. Investigators are now focusing the search to places Tibbetts was known to frequent in hopes of turning up new leads. Larry Nasser, the disgraced former USA Gymnastics team doctor who sexually assaulted dozens of young girls, is requesting a resentencing hearing. His attorneys say they believe that Judge Rosemary Aquilina had already decided to impose the maximum sentence before the sentencing hearing even began. Also included in the court filing, Nasser's attorneys claim he was attacked in federal prison hours after being placed in general population. Nasser is currently serving a 60-year sentence in that federal prison to be followed by up to 175 years in state prison for his child pornography and sexual assault convictions. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
All right, Francey, I got to ask you about this Larry Nasser situation, because this guy is saying, look, the judge is biased. I want a new sentencing hearing, this, that, and the other thing. So two thoughts right off the bat here. First of all, okay, you pleaded guilty, Nasser. That's one issue. And second of all, I agree judges should be unbiased, but look at the weight of evidence in a case where the defendant admits guilt. Francey, do you think this guy should get a new sentencing hearing or not?
Although at the time of the sentencing hearing, I did comment. I have a podcast I co-host on crime stuff, and I did comment on how troubling I found some of the judge's comments, and that could result in a reversal of his sentencing. But he did plead guilty. It's hard to feel sorry for someone like that, but we have to remember, we are all about fair justice in this country, and even though some might think that it is equitable punishment for him to be attacked, it's not. And he should be safe in prison, as much as, frankly, it pains me to say that.
Yeah, now the safety in prison situation, that I agree with. I agree with unbiased judges, but I think in a case like this, the judge was trying to sort of help the victims move on and see this as a situation of a point of finality in their lives from which they could then move on. They could look at that sentencing and say, it is done, it is finished legally, it is concluded, and from here we go forth boldly into the world. And I think that some of what she was trying to do was lead to that bigger picture healing that the victims so badly needed. But it raises a lot of questions as to who the judge should be protecting in the court, the victim or the defendant's constitutional rights, and that's a hard line for a judge to walk, I understand.
It is, Aaron. It's a hard line, but it is a line that the judge has to walk, because the system is all about the defendant. It's just about the victims, but it's ultimately about him and his punishment and the fairness of the system. Yeah,
we're going to wrap up this discussion. We're going to take a quick break. We will be back with more coverage in a moment.